Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-1218. Thomas Henry McLamb, petitioner versus National Labor Relations Board. Ms. Hazelwood for the petitioner, Mr. Sauter for the respondent.
Hazelwood, good morning.
Good morning. May it please the court. Alyssa Hazelwood for petitioner Thomas Henry McLamb. This case deals with two unlawful union actions. First, a union steward physically attacked a dissident at work while he campaigned for union office. And second, another union steward demanded that dissident's termination for the incident. The board created a narrative of events unsupported by the record to absolve the union for these actions. Substantial evidence does not support the board's decision. First, a union steward Boone physically assaulted McLamb in the workplace, directly in the midst of a heated election campaign. In spite of this, the board claims that at one point, while Boone, McLamb, and others—
Excuse me, you need to start at the beginning because the record I read was McLamb verbally abused her. He started it. Then she slapped him. He got her fired. He still has his job. If he gets a ULP claim, how does that promote industrial peace?
It promotes industrial peace because it protects Section 7 activity. Section 7 activity includes dissident union activity. He was a longtime opponent of current union leadership. And
what was the nexus between what he said about her and anything having to do with the union?
So first, the record doesn't establish that he said these things about her. The record established that he said that some people at Virginia—
Let's assume we disagree with you about that. Can you answer Judge Henderson's question? Assume we think he was talking about it.
Even if he was talking about her, she was still a union steward actively campaigning for his opponent. The record establishes, and the board concedes, that they were campaigning throughout the incident. They were campaigning at the beginning. The board says that the McLamb pivoted to this personal attack on Boone, which is unsupported by the record. In reality, especially on the record page—
How is it not supported by the record when what was said was so personal in nature? It was about her children and her license plates. That is not related to union activity.
So the record is replete with evidence that he continued throughout the day to say, I'm going to let it all out. I'm going to let it all out on Tuesday, which the board concedes is related to his campaign about union financial mismanagement. Just because he made some offhand statements to a union steward—
Deferential standard of review. It's just, if there's one way of looking at it, which is the way you're saying, but there's another way of looking at it, which is the way the board looked at it and said this was all personal in nature. And if it's supported by the evidence, we affirm, correct?
That's the substantial evidence is a high standard, but it hasn't been met here. Even personal statements, when made towards union stewards, have been protected when they're encompassed within the union campaign. I'd like to direct—
Are you asking us to hold that anything that's said during a union campaign is by its nature related to union activity? Like there cannot possibly be any personal statements if it's at a union event made to a union steward?
So I think the Fifth Circuit's ruling in general truck drivers is instructive here. In that case—
I asked you a yes or no question. Is that what you're asking for? A ruling that says that anything that happens at a union event directed to a union steward is by definition union related, that there can never be personal comments made at such an event?
Unless it is so opprobrious as to lose the act's protection.
That seems to be a different part of that test. Whether it's related to the union related activity is a different question than how extreme were the comments.
So we don't agree that the comments were extreme. But what,
Okay, that's not what I'm asking.
I-
I'm asking you that, is there ever a scenario in which personal comments can be made? An event that is a union-related event directed at a union-related steward. Can there ever be personal comments at such an event? Or are they all such comments by definition union-related?
I think they'd be by definition union related.
Thank you.
I wonder, I'll ask your opposing counsel about what I think are some inconsistencies between this NLRB decision and some other decisions where very similar speech was treated as campaign speech. That might just mean that those prior decisions were incorrect and this one was correct, in which case they need to explain why they departed, which I think they maybe did not explain. We'll get to that. On the merits, though, of whether this should be considered protected speech, if an employee comes to work and even in the midst of a campaign event, union campaign event, if the employee says kind of vile language, you know, you're a bad mom and, you know, you're stealing from the government, which is basically what he said here, it's disruptive. And let's say it had been not the union that punished him for it by hitting him, but it had been the employer that said, we just can't have this kind of personal attack in our workplace. That's not the kind of workplace we are. And so, you know, you're suspended for a day without pay or something like that. Then I think in order for us to rule for you here today, we would also have to think that the employer can't punish this speech, even when it's highly disruptive to the employer's workplace. It actually seems like a very anti-employer rule that you're urging us to adopt.
So I'm not here to defend employers, but I would point this court to Kiewit Power Constructors, which says not every impropriety committed during Section 7 activity places the employee beyond the protective shield of the act. And that was an employer ULP. And the question is not whether the outburst was something to be encouraged, but whether it was so unreasonable as to warrant denying the protections of the act.
Well, let me just ask this. What if instead of the union punishing your client by hitting him, it had been the employer who punished your client by suspending him from work for an hour with pay? Would that have been an unfair labor practice by the employer?
Yes, and in fact, there was an unfair labor practice by the employer in this case that was settled right before the trial.
And maybe that's right. That just seems like, boy, for us to come in and say an employer can't police disruptions in the workplace, it's a pretty tough rule for employers.
Well, I wouldn't say that they can't police disruptions, but I think it's important to look at what he actually said here. He didn't make any outrageous statements. He said some employees had Virginia license plates, Boone should pay her bills, and she should properly care for her children. And that's even taking the board's conclusion that he called Boone out by name. These are not the types of statements that the board or this court has held to be removed from the protection of the act. For example,
So do you think those statements are related to union activity?
so I think they can be related to union activity. And I think that if you look at the
How are those statements related to union activity?
So Mr. McLamb was a well-known union dissident because of the union financial mismanagement. Boone was a union steward in union leadership. Attacking her financial decisions, personal or otherwise, is related to union activity and to the union's financial situation. Moreover,
That seems a bit of a stretch, doesn't it? Because my understanding is his criticisms of the union officials and their finances was that they had fancy cars, that they were taking money. And in this context, he was apparently criticizing her for not paying her bills and not having enough money.
right, but I don't think it's our place to judge what the content of his criticisms of the union were.
But you're the one who said that the content of the criticisms was okay. You're the one who brought up.
Well, I think
content of the
it's in
criticisms.
it's in the wide range of reasonableness that employees are permitted to exercise their Section 7 activity. She was
But
active.
that's the question. Is the Section 7 activity, are these statements related to union activity? And your response is only based on the finances. So you agree that the license plate and the taking care of the children are not union activity, correct?
No. So the Virginia license plates comment the board found was disparaging only because the Virginia license plates required were cheaper. So that still relates to union financial mismanagement. When you look at the record with respect to how her children, the children statement, it said quit the union and take care of your kids. That was still related to the
He didn't
union.
say quit the union and take care of your kids. He said take care of your kids.
If you look at page, the record, page 253, Williams witnessed the quit the union, take care of your kids remark. If you look at what the record actually says, Boone testified that he said quit the union and take care of your kids, and Williams had backed that up.
I don't remember that statement in the record.
Okay, we'll give you a couple of minutes and reply.
Thank you.
All right, Mr. Sauter.
Good morning, Your Honors. May it please the court, Greg Soter for the National Labor Relations Board. Your Honor, this is one of the board's bread and butter cases. It's not making law, it's applying established law to the facts and digging deep into the facts because there are such a wide range. Yes.
Start there. I don't think either party cited this NLRB decision, Pier 60, which is from 2015. And it held that the following is campaign speech. It was posted on Facebook about how an employee was treating lower level employees.
I'm sorry, an employee.
Well, I guess basically
Supervisor
how a
or-
manager was treating employees.
Okay. Yeah.
So this was basically, it's going to end with the sentence, yes, for the union. Okay, so this certainly sounds like campaign speech. It's posted on Facebook. I'm not going to use the bad words, right? But the guy's name was Bob. Bob is such a nasty MF. Don't know how to talk to people, exclamation marks. F his mother and his entire effing family, exclamation marks. What a loser, exclamation marks. Vote yes for the union. Now that ad hominem attack was considered campaign speech by the NLRB.
Right.
And it's hard for me to see how that ad hominem attack is campaign speech when this ad hominem attack was not campaign speech.
Well, Your Honor, unfortunately, I don't have the Pier 60, immediately in my mind. I assume the board found that the association between yes for the union and the fact that this person was a manager was enough to make a campaign speech.
I thought you might say that. So let me.
No, I'm. It's a question I'm asking.
Yeah, I think that part of it is made a little bit more clear when the last sentence is yes for the union.
Right,
So I
right.
get that, but I think imagine that the only reasonable way to read what was said here is there's a debate about the union. There's a debate about whether people are stealing money from the union. In the midst of this debate, McLamb makes some very, I think, beyond the line, like personal attacks, and doesn't end it with the sentence against a representative of the union.
Right.
And doesn't end it with vote for the union.
Right.
But maybe the only reasonable way to interpret what was done is a bunch of campaign speech, an ad hominem attack with an implied at the end, vote for the union. It doesn't seem like this would be any different than that. So I guess what I'm saying is, would this case be different if McLamb had ended his attacks with the line, vote for the union or vote against the union?
Well, as you know, I can't respond to what the board would do because, the board, I'm not the board. I'm just the board's my client. I can only give you my personal view on that. My personal view on that is that if I was to go by Pier 60, then I guess I would say, the board has held that something similar in Pier 60 happened. So it would apply the same way here. The point here, though, is not only did he not make those statements, that statement, he didn't make any link between his attacks on Boone and her license plates and her ability to pay bills and her union activity, and the union. I'm sorry, he didn't make a link between her personal ability to pay her bills, take her kids, etc., and the union.
I think Boone says, and I'm in the JA here, that the question is, what did McLamb say? And she says, it was just the same, you know, about not paying the bills and take care of, tell them how you stole the union money. I'm like, what money, McLamb? And then he says, I'm going to let it out. I'm going to let it out on Tuesday. So it seems like even Boone understood there to be some connection between an attack on Boone's honesty, you know, and an attack on the honesty of Boone's union.
That's a good point, Your Honor. But remember, we're not looking at what Boone understood. We're looking at what employees witnessing this would have understood.
What if there had been a presidential debate? It's not too far away from real life, where, you know, they're debating policy, they're debating who to elect. In the middle of the debate, one candidate just turns to the camera and says, my opponent is a bad parent and is not trustworthy with money. And then they go on arguing about politics.
Right.
That seems like that's campaign speech, right? Even though it's very ad hominem, it's you know, it's very personal.
That's true. Boone wasn't running for election, though.
Well, but she was a surrogate for people running for election.
She was a surrogate for people
You can
running.
take my hypothetical, put it on CNN, and have two surrogates arguing against each other about who to vote.
I think again, the question is, how would employees witnessing this see it? Would they see McLamb attacking Boone as a surrogate by saying, you have Virginia, as a union surrogate, by saying, you have Virginia license plates, you don't pay your bills, and you don't take care of your kids? Would those people make the link between those accusations and the union and its alleged mismanagement of funds and so on and so forth? Now, in the setting that you're talking about, we're watching TV, there's two people, two talking heads, right? And we know one of them is for one side, one of them is for the other. That's why they were brought here.
What if I agree with you that this is not protected campaign speech, but I think it's just squarely inconsistent with Pier 60, because it really doesn't matter if vote for the union is stated or implied. What are we supposed to do? What should I do then?
I think, Your Honor, Pier 60 is one single post on Facebook. Here you have really about 10 or 15 minutes, I'm not sure, of back and forth arguing that is witnessed by multiple people, and where there is no mention of the union. And I mean, hardly any mention of the union. In fact, you have several people who testify. Lako King, for example, is asked, did you ever hear him say the union can't pay its bills? No, he didn't say anything about the union. Boone, did Mr. McLamb say the union doesn't pay its bills? No. Butler, can you recall him saying the union doesn't pay its bills? I can't recall him saying that. He was just rambling on about a lot. So that's the first thing. The second thing you have to look at is Boone's reaction. Boone, when she speaks back to McLamb, she doesn't mention the union based on all the testimony of all the witnesses. She says, leave me alone, stop harassing me, leave my name out of your mouth, stop putting my personal business in the street, stop harassing me, keep my kids out of it.
I mean, I think there's no doubt it was personal. The statement was personal. And
Right.
then I guess I'm wondering from you, can you help me know how to draw the line between, in the midst of a debate about a union campaign, how do I draw the line between personal attacks that are connected to that debate and personal attacks that are not connected to that debate?
Well, you're hitting the nub of it. And that's why I was saying earlier, this is the kind of bread and butter cases that the board deals all the time. That the board's job is to thread that needle along all of these cases as best it can. As the court knows, it's not exact science. what I would say is there's a case that McLamb cites, which is, I think, instructive, and that's Local 806. In Local 806, you had a union that was led by 3 members of the same family. They were all on the board. One of them was president, et cetera. Those people, and there was a bunch of dissidents who were upset with the union. Those people, that family, they were making the policies that the dissidents were upset about. And over the 4 years that this argument happened, it became more and more contentious. And more ad hominem attacks were thrown back and forth. And what the board found is that in that case, the Leon family, as they came to personify the union. Their person became indistinguishable from the union. And therefore, it was no longer possible to really tell to really separate the ad hominem attacks by the union members from their picketing and protected activity. It all sort of melded as one. I think maybe that doesn't exactly answer your question, but I think that shows a point where the lines blur. In this case, we don't have this blurring of the lines because Boone, again, is a steward. She's not on the executive committee. She's not making policy. She's a driver, right? She
responds to his statement by saying, talk about other candidates' business, as if she's a candidate. Of course, she's not a candidate, but she's an incumbent and a surrogate for other candidates.
Right. She tells him, and I think that supports the board's view. She's actually telling McLamb, go do your dissident activity. Go talk about how the union is corrupt and how they're ripping people off. Just leave me out of it. I don't want anything to do with this.
Let me ask you about Ms. Williams.
Yeah.
And there was a dissenting member of the board.
Yeah.
Who makes a pretty strong argument, I think, that the majority said, well, when the management said you had the manager, you had Boone, and you had Williams, and the manager says to Boone, slapping someone is a terminable offense. He hadn't mentioned, as far as I can tell, he hadn't mentioned McLamb or anything.
Right.
And suddenly Williams says, you fire her, you got to fire McLamb.
Mm-hmm.
That doesn't sound conditional to me.
Well, there was an if before that, but I understand your point.
But
I understand your point.
That was in response to the management saying, this is a terminable offense to slap someone. Mm-hmm. And she interjects Lamb by saying, well, you're going to fire her, you got to fire him.
So I think, the board sort of explained that as sort of raising the stakes, right? The way I read that is that what Williams was doing is variation on an argument I've heard anyway, which is if you do A, you're going to have to do B, and you don't want to do B. So you're better off not doing A. And that's why the board found that she wasn't actually saying McLamb should be fired. She was trying to make the case that for the employer not to fire either one of them. Because, and you have to remember, and this goes to the overarching negligence standard this is a good faith issue. Did the union, even if this could be construed as an implied request, did the union violate its duty of fair representation? And it's a high bar to show a violation of that good faith standard.
But it seems to me that the argument that you're making relies on this idea that what Williams was saying was, I didn't mean to say fire him. I just meant, treat them equally. Don't fire her. That's kind of what the argument is. But the ALJ found, and I'm quoting from JA 597, Williams testified that she told Marshall that whatever you decide to do to McLamb and Boone, it should be fair, it should be equal. And the ALJ, this is the board talking about what the ALJ said,
right.
That this was not credible. It discredited that motive. So what do we do with that? That the ALJ seems to have specifically discredited the very I guess, factual finding that the
Well-
board wants to draw, the majority wants to draw.
Right. Well, I submit there's a difference between not firing either one of them and treating them fairly. Right? I mean, for them not to be fired, there's still a range of punishment and differential punishments that could be imposed between the two of them. And that's what the board is getting at. Don't fire them. Do with her what you want. Suspend her for as long as you want. Give him a slap on the wrist. Just let her keep her job.
But he didn't say suspend her and give him a slap on the
No.
wrist. She said treat them, at best, she said treat them equally. The best argument for the board here is that she was arguing for equal treatment.
I think the best argument is that she was arguing for them not to be fired, which is a distinction.
thought she
I
said
understand.
Treat them equally. I mean,
Well, that's what she testified about, and she was discredited about that. Right?
she being,
Williams.
right.
Williams testified that's what I wanted, and she was discredited.
So either we don't believe Williams, in which case,
Well, the board didn't,
well,
right?
I mean, I don't know.
So,
I mean, fine, but if Williams is not credible, I mean, I agree Williams is not very credible in this situation.
right.
Why are we saying that there was fair representation by Williams when Williams's best defense was not a credible defense?
Well, it's fair representation by the union, Your Honor.
She was the union rep.
Right. But so there's a couple things here, okay? First, there's and this is what I was going to get to before, and why it's such a high burden to show a violation of the duty of fair representation. Williams is not an attorney. She's not even a professional union employee. She's a steward. She drives all day, and from time to time, she puts on her steward hat and she shows up. In this case, she gets called in to do that. She is not used to weighing her language or thinking about how it's going to be construed. She's just thinking on her feet and trying to come up with what is her purpose there is to try and minimize the damage for Boone. She knows this is bad for Boone.
Why is that shouldn't her purpose also be to not throw McLamb under the bus? I mean, she's supposed to represent him as much as she represents Boone, right?
Right. Right.
I mean, can you imagine if like I'm a defendant in a trial and there's another co-defendant and my lawyer tells the jury, if you're gonna convict the co-defendant, you got to convict this one too. That'd be it. You wouldn't want that person to be your lawyer, right?
No.
If you were a union dissident, would you want Williams to be your rep?
Again, Your Honor, Williams is not a lawyer.
Listen,
She's doing her best under the
I
circumstances.
get it, but I mean,
And so,
do
and
you-
if she shoots her mouth off, you know, is it negligence or is it intentional? Was she trying to throw, I'm sorry.
I just don't see why that's relevant, that she's not a lawyer and she's doing her best. If she
Well, it goes to the
makes
good
a
faith standard.
statement, regardless, that seems to imply that somebody she represents, McLamb, should be fired, does it matter that she was doing her best?
I think under the negligence standard, it does, Your Honor.
Well, negligence is an objective standard too.
Right.
Not a
But
subjective
if she-
standard. We should have pity on this woman who doesn't know what she's saying.
no, not at all.
You're
But I
supposed to
mean,
follow the NLRA, right?
right,
Even
But
if
I
she's
mean-
not a lawyer. I
right.
just don't see how it matters whether she's a lawyer.
Well, the point is are we finding that she, you know, had an ulterior motive and an agenda and she was trying to throw McLamb under the bus? Or was this an instance of,
Wait, is this a matter of intent? Are we supposed to?
No.
Was she trying to throw him under the bus, or are we did she do so by what she said? Isn't that what we should be looking at?
yes, that is,
I just don't know why we're focusing so much on her and what
because,
she was thinking. I don't think why is that relevant?
Your Honor, once you find, and if this court finds that her statement was an implied request to fire McLamb, the next question is, did she act in bad faith? Right? Did she violate the duty of fair representation, which is a bad faith standard, which is, again, a tough burden to meet. And so that's when you have to look at the context. That's when you have to look at, you know, why was she there? Why, as the board finds, why would she walk in there to defend Boone? And then minutes in, she turns to arguing that McLamb should be fired. That goes completely against her main purpose in that meeting, which is to limit the damage for Boone. And so it's much more reasonable to draw the inference that the board did, which was that she was continuing on her effort to prevent the damage, to limit the damage for Boone by arguing that neither of them be discharged.
I think a more precise way to say it is not that it goes against her purpose. It goes against what the NLRA requires her purpose to be, but seems quite consistent with what was her most likely purpose, which was to punish a union dissident. That's sort of like the Occam's razor simplest explanation for what happened. She wasn't there to talk about McLamb, but she didn't like McLamb, so she tried to punish McLamb.
I think you can see it that way, but again, the question is the board's inference reasonably defensible? You may disagree de
The board
novo.
didn't decide this issue based on bad faith. The board said she didn't advocate for him to be fired.
And then the board said, even if she did, the union didn't violate its duty of fair representation, right? The board didn't stop
I thought the
there.
board relied on just that statement in isolation and said this statement, which is if you're going to fire her, you should fire her too, is not a request to
That-
fire McLamb.
That was the first part of the analysis. That's page 4. The last paragraph of page 4, we find that, that statement couldn't be found to be an implied request. However, the board continues, even if we were to apply the second part of the analysis for duty of fair representation, we would find that the union didn't didn't act in bad faith. So, and this goes back to what I was saying earlier. When I got this case and I read this thing first, I wasn't thrilled. I sort of looked at my supervisor and was like, really? But even if you disagree with the way the board,
Just concede that your case is weak?
no, I can see that my personal initial opinion upon getting this case was, oh, I don't like this. Now, after that, I spent a couple months on this case, reading the entire transcript and briefing it, and now I'm quite confident standing in front of you in both of the board's decisions. However, even if, and this is the important point, even if you disagree with, would have decided this case de novo, the question is the board's inference reasonably defensible? And under the rational basis standard here, would the facts of this case have required the board to find the violation? Was that the only outcome here? Or did the board reasonably find, even if you may disagree, was there a reasonable basis for the board to reach its conclusion? And you may not agree that there was a reasonable basis for the board to find that the statement itself wasn't an implied request. However, I do submit that there is absolutely a reasonable basis for the board to find, based on the entire circumstances and the union's history with McLamb, that they were not trying to throw him under the bus, that she was doing her best, and that it was not some kind of devious plot to get rid of him. There was no evidence that Williams or anybody in the union had it against McLamb. He had, I think you can rightly say, in the 7 years he'd been working there, he'd been a thorn in the union's side. I mean, within months of being hired, he petitioned for decertification.
There's some evidence that not everyone in the union liked him.
Right. He was,
One of the union stewards hit him.
the union steward hit him because of the personal insults that he
And I have to say, I appreciate your candor. I welcome it. I admire that you recognize that when you first look at this case, it looks the way you said it looks. And I appreciate that you're here to represent the board, and you're doing, I think, a better job in your role as an agent for the board than Williams did as an agent for McLamb.
I went to school for
The
this.
point of a union, I think, is to protect workers. And,
Absolutely.
McLamb was a worker. The union was
Absolutely.
supposed to be there for him. So, I mean, it seems like a very in the same way that I think arguably McLamb is arguing for a rule that might ultimately be quite bad for employers.
Right.
I think on issue one. On issue two, I think the board here is arguing for a rule that would really be a very anti-worker rule, because
What would that
union-
rule be?
that the workers' union, right, is allowed to just like sacrifice the worker when they don't like his speech.
But and this is what the board relied on. It makes no sense for Williams, where she is at that moment, to sacrifice McLamb, because then she's sacrificing Boone, and she doesn't want
Boone had just hit someone, so she was gonna get disciplined. And then
disciplined, not fired, hopefully. I mean, nobody, this was a preliminary investigation meeting, right? This happened the same day. Williams doesn't know at that point what the employer is planning to do with Boone. It's possible even Marshall doesn't know, you know? So she's really, if it might be different if this was, you know, later on a meeting with management, Boone and her steward saying, okay, listen, you hit somebody in the face, that's unacceptable, you're fired. And then Williams stands up and says, well, in that case, you have to fire McLamb too. You know, I could see there, in that case, it would be a much stronger argument for your position. But in this case, where she's really flying blind, I don't think it rises to that level.
Was that the only statement she made about McLamb during this meeting?
Yes, as far as the record shows, yes.
So I guess the best argument you can make is that at least the finding of no bad faith is supported by the record, because it's one isolated statement about McLamb. The entire context of this is, you know, trying to save Boone, and it's a conditional statement. Like, if you were going to fire her, you would have to fire him.
Right.
And so I guess that would be your strongest argument, in my opinion. It'd have to rely on the bad faith prong, I think.
I think that's one of the best arguments, maybe the best in your view. I think the argument that, you know, about the context and really the purposelessness for Williams in this situation during a preliminary investigation of where they don't know what the employer is going to do with Boone, of just, you know, giving up right there at the beginning, saying, oh, you've said she could be fired based on what she does? Okay, well then in that case, fire her, just fire McLamb too. That just does not, I think you might think that you might view it, again, de novo, as, you know, just evidence that she just gave up and decided to throw the baby out with the bathwater. I think the board's inference that she was just trying to convince Marshall not to fire either one of them, I think it is certainly reasonable and should not be overturned.
I'm sorry.
You haven't mentioned the fact, I don't think, that the ALJ who actually heard this Miss Williams did not believe anything she said. She found her testimony slanted, gratuitous. I don't know all the adjectives she used.
Right.
So you're painting a picture of Williams. We don't know her. Nobody in this room knows her. But
No.
there is an ALJ who actually listened to her testimony and didn't believe her.
Right. But we're not looking at, all we have, right, is what happened that day. All we have is the allegedly implied request to fire McLamb. All we have are those words, right? So, and the Boone corroborated Williams and said, yes, she said words to that effect, okay? So.
But what do we do with the ALJ factual finding that, I guess Williams testified that all she meant when she said that was, I just thought you should treat them both fairly, and he discredited that statement. Do we defer to the ALJ's credibility findings and factual findings?
Yeah, the board deferred to them, and the board said it wasn't going to rely on Williams. The board didn't overturn the judge's credibility findings. What the board found is that in this context, the way it happened the employer would not have understood that as a request to fire McLamb. And even if based on the words itself, it would have understood that. There's no reason, it doesn't make sense that she was, again, within minutes of going in there in this preliminary meeting, deciding, you know what, I give up, just fire both of them.
This is actually, I don't really understand how this works between the board and the ALJ. If the ALJ makes a finding that this statement was a statement to fire McLamb, the board can say it was not a statement to fire McLamb.
The board looks at the words that were said at that moment, right? So we were talking before, it's not intent, right? It's whether, as far as the language goes, the board looks at the language itself. Now, her justification for it.
That's on prong one of the test.
That's on
which
prong
is
one of the
whether-
test.
So on prong one of the test, which is, was there even a request to fire McLamb? The board just looked at the words and said, this is conditional. This is not a request to fire McLamb.
Mhm.
But if this panel believes that prong one isn't met and we need to go to prong two, and we're looking at bad faith, and the ALJ has said, when Williams testified that I wasn't saying that, I was just saying treat them equally, and the ALJ discredited that and said, no, what do we do with that if we're on prong two, not prong one?
Well, you go back to what we were talking about earlier about good faith. If the whole context about it doesn't matter, if you don't think the context and everything leading up to that supports the board's conclusion, then you go back to what the board said. It's page 4, last paragraph of page 4, which is at most this was a single statement during a preliminary meeting, and it wasn't repeated afterwards. It was inartfully said, yes, but it did not rise to the high bar of bad faith.
And it's still an objective standard.
Yes, yeah.
All right, thank you.
Thank you, Your Honors. With that, we respectfully request that this court deny the petition for review. Thank you.
Ms. Hazelwood, why don't you take 2 minutes?
Thank you, Your Honor. Just one quick point on the second issue. The standard is not whether the union steward acted in bad faith. There's a heightened standard when a union steward requests or attempts to seek an employee's discharge. And that creates a rebuttable presumption that it acted unlawfully that can only be rebutted by a good faith showing. That the union's actions were done in good faith based on rational considerations.
Isn't the standard in a particular context that's not applicable here? This rebuttable presumption, I thought that was in a different context.
No, that's the heightened standard here. If there's a demand, a discharge demand or an attempt to discharge, then that heightened rebuttable standard is the standard that's applied in this case. But I wanted to just return to the first issue. So with respect to the first claim, the standard is when an objective employee would have understood the attack to be, whether it was campaign related to Mr. McLamb's Section 7 activity. And there's evidence in the record to suggest that that was the case. So for example, on page 177, Boone said, when asked whether McLamb's statements were made about him, she said, at the time I was the only person in there campaigning. After Boone's attack, Williams turned to another candidate for the union office and said today was not a day to be campaigning, suggesting that there was an understanding that the campaign continued throughout the event. On page 273 of the record, when Williams was asked what McLamb's reputation was, when she was asked what "you know how he is" means, she referred back to the fact that he doesn't like ATU, and when someone is showing support for ATU, he speaks out against them. Similarly, Butler also, when she testified at record, page 211, that McLamb made prior similar displays by down-talking the union. I think this context is important and essential to this case. No, there are no questions.
All right, thank you.
Thank you.
Case number 23-5119. Thomas G. Coleman, Major, U.S. Air Force, retired, appellant, versus Gary A. Ashworth, Acting Secretary of the Air Force. Mr. Thayer for the appellant, Ms. Otusa for the appellee.
Mr. Thayer, good morning. Oh,
Morning.
Let's wait till the courtroom clears. All right. Go ahead.
Chief Judge, Your Honors, may it please the court. My name is Dylan Thayer, and I'm here on behalf of the appellant, Major Thomas Glenn Coleman. The question before this court today is, when a military correction board identifies an injustice, is the board bound to fully correct that injustice? And the answer under the law of this circuit is yes. Major Coleman requested 49 days of constructive service time from the Air Force Board for the Correction of Military Records to compensate him for the 8 to 14 months of time of which he was wrongfully deprived earlier in his career as a result of the Air Force's failure to properly correct the bureaucratic errors regarding his waiver and transfer requests. The board agreed that Major Coleman had suffered an error or injustice, but the board never fully corrected that injustice. In 2011, when
What was the error?
the error was, Your Honor, when Major Coleman moved to Singapore in June of 2006, he should have either been transferred to inactive status effective December of 2006 pursuant to Air Force Instruction 36-2115, or he should have been granted a waiver of service for that year.
Let's take both of those. Let's start with the waiver. What is your authority that shows the Air Force should have granted the waiver faster than it did?
Your Honor, the Air Force has this waiver process, and the board recognized in determining Major Coleman's application that he had suffered an injustice. Whether that was an injustice as a result of the waiver or the transfer, there's not a specific.
Stick with the waiver. What rule did the Air Force break?
The Air Force did not break a specific rule regarding the waiver, Your Honor. There's no rule that necessarily requires the waiver to be processed within a certain period of time. But Your Honor, as I mentioned, the board recognized that there was an injustice which contributed to his discharge.
I mean, we have this precedent that says the alteration of a record may correct one injustice only to commit another, or perhaps only to incur some other equally significant institutional cost. So I get that maybe in another circuit, all you would have to do is show that there was an incorrected injustice. But it seems like our precedent suggests we're not going to vacate every military board decision that has an injustice.
2 points on that, Your Honor. So yes, Christ, Your Honor, does give the board discretion to recognize an injustice. That's correct. When the board is determining whether an injustice has occurred, the board has complete discretion. However, under this court's holding in Hasselwander v. McGee, the board is required, or v. McHugh, excuse me, the board is required to correct an injustice which it identifies. If a board does not correct an injustice which it identifies, it is acting contrary to its statutory mandate under 10 USC 1552.
So it seems to me that there's a tension between the two forms of error that you've identified. One is you're saying he should have gotten a waiver, which would have allowed him to continue in active duty and earn more points. And the other is he should have been inactive, which would have taken him like off the clock for promotion. You can't do both. Like you're either inactive or you get a waiver and you're active. And so there's a tension there. And it just seems to me underlying all of this is your client's failure to request either of those things in a more timely manner. Because he doesn't ask for the inactive status, I think, until September of 2007, when he moved in June of 2000, was it 2006?
He moved in June of 2006, Your Honor.
Right, but he doesn't request the inactive status until September, and he doesn't request the waiver, right, until.
He requested the inactive status in February of 2007, Your Honor.
Right.
He initially requested the
Oh,
waiver.
the waiver was
The
September.
waiver wasn't,
Yeah,
so
thank you.
the waiver was initially requested in September of 2006.
Right, and the inactive status was requested in February of 2007.
That's correct, Your Honor. That's correct, Your
And I
Honor.
understand, let me just complete my thought, which
Sure.
is, I understand that he knew he was being transferred to Singapore, right? And
That's
he
correct,
knew
Your
that
Honor.
3 months before he went in June, so he knew that in March. So he could have requested either the waiver or the inactive status before even he left in June. And so given that he kind of sat on his rights and didn't request either of these things, and then when he did, they were conflicting things, it's really not clear to me where the injustice is.
Well, Your Honor, a few points on that. So the injustice is, first of all, the onus is on the Air Force under Air Force Instruction 36-2115, paragraph 4422. When the Air Force is made aware that a reserve member is moving to a country where there is no status of our forces agreement, as is the case in Singapore, the Air Force must transfer the member to inactive status. Now, it's not clear when that transfer should occur.
And it doesn't say that that has to happen sua sponte as opposed to upon the application of the service member.
It's my understanding, Your Honor, that the unit is required to do that of its own initiative.
But
Can you
where does
read-
it say that?
Can you read that? I don't think it says that either. And you could maybe convince me otherwise if you read all of 36-21-15-4422. But I actually didn't see you quote all that in your brief. I didn't see you attach it to your brief. I Googled it and it was awfully hard to find. I'll tell you how I found it. It's with the Wayback Machine. So I'm not even sure you can rely on 4422 when you didn't really make it available to us.
Well, that brings me to my second point, Your Honor. Even if this court finds that there's no requirement that the unit acts sua sponte to transfer Major Coleman, it's not relevant because the board recognized that Major Coleman had suffered an injustice from his discharge. Here's what the 2016 board had to say. While the board recognizes that some error or injustice contributed to Major Coleman's discharge, he has been made as whole as this board is able or willing to make him under the
And
circumstances.
I think one way to read that is all the injustices have been corrected.
Your Honor, I believe that that's not consistent with the plain language of what the board is saying. The board said some error or injustice contributed to his discharge.
And they made all kinds of corrections. I mean, they gave him credit for doing a ton of work he never did. They gave him years worth of good years when he wasn't working.
Your Honor, they moved his transfer to inactive status back from September of 2008 to August of 2007 in recognition of under Air Force Instruction 36-2115, because he requested the transfer to inactive status in February of 2007, it should have been effective as of August 2007. So that was not compensating him for work he had not performed, Your Honor.
Can I go back to 36-2115, Judge Pan's questions about it? I mean, do you concede that we really can't rely on an authority that you didn't make available to us?
Your Honor, I concede that you can only rely on the authority to the extent that it's quoted in our briefs and the government's briefs, and that you can't rely on anything outside of that. But again, Your Honor, I would posit that because the board recognized that there was an injustice here, the exact language of Instruction 36-2115 is not the precise issue before this court.
Fair enough. Now, it seems like you're maybe hanging your hat on that board quote about an injustice. And so I guess would you concede that if I read it differently than, if I read that sentence differently than you read it, if I read the board to have said there were injustices in the past, we corrected all of the injustices that have happened, there are no remaining uncorrected injustices. If I read it that way, would you concede that I'm supposed to rule for the government here?
Well, Your Honor, I think you can't just rely on that one sentence. You have to rely on the board's full constellation of actions here. You have to rely on the 2011 board, which, as you mentioned, recognized that he'd suffered an injustice as a result of the Air Force's bureaucratic waiver bungling. Now, they didn't fully correct that injustice. You can rely on the 2013 board, which also granted him relief, even though they didn't fully correct the 8 to 14 months of time for which he has never been compensated. And you can rely on the 2019 board on reconsideration, which said that it concurred with an advisory opinion, finding that Major Coleman was unable to serve.
Sorry, you finished sentence.
Was unable to serve from May 11, 2006 until August 17, 2007, because he hadn't received his transfer request. So, Your Honor, that one sentence,
You're not
you're right.
hanging your hat entirely on that.
That one sentence is very important, Your Honor, because it does get to the root of the issue, but it's, the board has acted in a widely inappropriate way here.
It seems like in 2011, during that, there was a decision in 2011, and there were arguments made leading up to that decision. And I think your client asked that 2011 board to make his inactive status effective June 2006. And they declined.
The 2011 board, yes, Your Honor, he did ask that his status be made effective June 2006, and he argued in reply to an advisory opinion that if they weren't willing to do that, they should do it in December of 2006. That's correct, Your Honor.
And so they declined to give him all the relief he asked for then in 2011.
That's right, Your Honor.
It seems a little weird that we're litigating that 2011 decision now, whether it's that there's a 6-year statute of limitations, I think, for board to challenge board decisions in court, or whether it's forfeiture. I don't know exactly what the.
I understand what you're getting at, Your Honor. I understand what you're getting at, Your Honor. Here's why we're litigating this now, Your Honor. You're right. There is a 6-year statute of limitations for board decisions.
I'll let you say why you're litigating it now, but before I forget, could you have gone to federal court after 2011 and challenged that 2011 decision for not making him inactive effective June 2006?
I suppose Major Coleman could have done that, yes, but Major Coleman wasn't aware in 2011 that he was only going to be discharged 49 days prior to achieving his 18-year right of safe harbor status. So that's the key, Your Honor, is that yes, he could have gone prior to, following that decision, but he went to the board in 2016 in an effort to correct the new injustice, which was because the board had failed to fully correct the record in his previous applications, he was then denied his statutory right to attain 18 years of safe harbor because he was never fully compensated for that time.
But isn't the other piece of this that he couldn't be passed over promotion twice within the time allowed? And your arguments are saying he should have gotten, I guess, more time in which to prove himself. But if he was just not going to be promoted anyway, twice within this time frame, these arguments don't really get him where he needs to go, right? Because there were 2 times where he was not promoted, and without getting promoted, he still isn't entitled, right?
Well, so Your Honor, there's 2 things that are working together there. So yes, a service member can be discharged or will be discharged when they're twice passed over for promotion, if they're of Major Coleman's rank. However, if a service member attains the 18-year safe harbor under 10 USC 12-646, they cannot be discharged for failure to promote. Had Major Coleman been able to attain time towards those 18-year safe harbor for retirement, as he should have been permitted to do and would have been able to do had it not been for the Air Force's bureaucratic errors during those 8 to 14 months that I've been talking about, he would have attained the safe harbor. And at that point, he can't be dismissed for failure to promote. So the failure to promote, Your Honor.
The facts are just pretty intricate and convoluted, and it's just
Sure, Your Honor.
He wouldn't have been up for promotion twice before that 18-year period anyway.
He was up for promotion twice and he was passed over twice for promotion.
Exactly.
But that's not relevant, Your Honor, because that has no impact on whether he can attain the 18-year safe harbor status in this circumstance. Because if he'd been able to earn that time, he would have earned the 18 years. And at that point, he can't be discharged for failure to promote.
I guess my question is, if he has had, he has had a few different I guess, promotion reviews and has been denied. And I guess my question is, if he's denied twice before he even gets to 18 years, then the 18-year sanctuary is of no moment. And are we clear on this record that he would not have been denied twice, even if he had, I guess, gotten some more corrections? Because with all the corrections, his promotion clock has already been extended beyond what's normal. And so it's just not clear to me on this record that he would not have had 2 promotion reviews in which he did not get promoted, even before he got to the 18-year mark on this record.
So if I understand Your Honor's question correctly, he did have 2 promotion reviews where he was not promoted. That's what happened.
And then he'd be discharged before the 18-year mark, even if you had made these corrections.
But Your Honor, it's not automatic. So you're still able, even after you're passed over for promotion. So he was passed over for promotion, but he wasn't automatically discharged. You're still able to earn time toward your clock for the 18 years of retirement. And he was having time taken off of that clock because he wasn't in an active status during the 8 to 14 months, which he lost as a result of the bureaucratic errors. So he's having time taken away that he can't serve, which doesn't allow him to get to 18 years of retirement, all the while his retirement clocks are running. So it's getting him closer and closer to that deadline, and he's not able to get what he ultimately has earned. Does that make sense, Your Honor?
It does make sense, but it's still a piece of the puzzle that he has just not earned promotion.
It's true that he has not earned promotion, Your Honor, but it's not.
Because the other way to
ultimately-
get around this is to earn promotion, and then we are not.
Of course, Your Honor. Of course it is, Your Honor. But ultimately, it's not dispositive, because even if he doesn't earn promotion, he still has the ability to earn that time in order to get to 18 years of safe harbor, and he was deprived of that opportunity, Your Honor.
I have one, I think, technical question. Do you know if when he moved to Singapore in June 2006, did he have a military service obligation?
He had an obligation to continue to try and earn time as a reserve service member toward his retirement. That's why he sought the waiver, Your Honor. He sought a waiver clearing him of his requirements for that year, so that the time would no longer continue to run.
Until the waiver came through, and to be honest, to the extent military service obligation is a term of art, I'm not an expert in that area of the law, so I'm not exactly sure what that term of art means, but it's referred to in 362115. And so I'm just trying to figure out whether before he got the waiver, did he have a military service obligation?
All reserve service members have to complete certain requirements, Your Honor, each year in order for that year to be considered a good year
Like
for their retirements. Right, 50 points, 35 participation points plus the 15
So I think that's
points.
a yes, until he.
Right, yes, Your Honor, yes.
Okay.
Yes.
And can you explain that waiver? Because this was kind of interesting to me. He was trying to waive the bad year designation for 2006 in order to get.
He was trying to
transferred.
obtain a waiver for the coming year, Your Honor. Because of the move, the waiver would mean that he wouldn't have to fulfill the service requirements for the coming year. And so therefore, it would not be counted as an incomplete year on his record. So he would have an opportunity to earn the time going forward. That waiver ultimately
No,
wasn't.
I understand, but the way that it's been briefed, it said in order for him to be able to continue to earn points in his new assignment, he would have to get a waiver of the 2006 bad year. That's the way it was briefed. And I was
Yes.
confused about waiving a bad year. Is that waiving a bad year for purposes of transfer versus waiving a bad year?
If I
If you could just apply and waive a bad year, then.
it doesn't work that way, Your Honor. If I phrased it that way in my brief, what I was driving at is what I'm saying now, which is you waive the requirements for that year. And when you apply for that waiver, you can't just snap your fingers and there's an old bad year and you get rid of it.
But that 2006 year ended in April of 2006. So that's why I was confused why you had to waive the 2006 year when you were moving in June of 2006.
Yes, Your Honor. I'm not clear myself as the intricacies of exactly how that process works. What's relevant for the purposes of this appeal, Your Honor, is that by not obtaining that waiver, he was accumulating time, which was being taken off of his clock, which would allow him to attain 18-year safe harbor, and he was not earning points, which could allow him to earn complete or good years toward retirement.
And why didn't he apply earlier for either the waiver or the?
For the waiver, I'm not certain of that, Your Honor, but what I am certain of is that the board never in any of its decisions stated that Major Coleman had done anything wrong or failed to meet any of his obligations or requirements regarding applying for the waiver or applying for the transfer request.
All right, we'll give you a couple of minutes to reply. Ms. Otusa?
Good morning, Your Honors. May it please the court. Christina Otusa for the Secretary of the Air Force. It appears based on the exchanges that have just taken place that the court already has very thorough understanding of the case, and the Secretary completely agrees with all of the court's comments that have been made thus far. One additional point that I would like to add is that Mr. Coleman never applied for a change to his record based on this waiver argument. In his first application, he had only made the argument regarding the transfer to inactive status, and that was the sole issue that was addressed in that opinion. Now, of course, the Secretary has argued on appeal that this issue is forfeited because it was never argued for the district court, and therefore the Secretary relies primarily on that argument. But had this issue been clearly addressed such that both the district court and the Secretary understood that he was making this argument, the Secretary would have explained that this theory just does not add up. I think that the court has already noted that the actual years at issue, there's no such thing as a...
So, based on my reading of the record, I think Coleman did preserve the challenge to the waiver request, and I'm just looking at the joint appendix before the board. He raised it. He requested remedies for the delay in transfer as to inactive status, as well as the waiver argument. He did that in I think the third request, but in any event, and then I think he did raise it also before the district court. So on the merits though of this waiver argument, all the board said was, we don't see any unremedied injustice. And that's a pretty broad statement. So what in your view on the merits
Sure.
defeats the waiver argument? Sorry, the argument about not addressing his waiver request.
So Your Honor just noted that it was raised in the third application. That argument was not raised in the third application. It was raised in the application for reconsideration, and therefore that is why it's actually not specifically addressed in the board's decision on the third application, because it was not an argument that was presented to it. Now, as I just noted, Mr. Coleman did raise this argument in the application for consideration, and this is something that was specifically addressed by the advisory opinion, which was effectively agreed with and incorporated by reference by the board's decision. And the advisory opinion noted that there's no such thing as a waiver of your retirement and retention year points. That's just not a thing that exists, and the advisory opinion provides the citation for the policy on that issue. And in response, Mr. Coleman had the opportunity to present a rebuttal, and he presents no evidence to the contrary. So this idea that this waiver of obligations has anything to do directly with retirement or retention year points is just completely unfounded. And I think the reason—
I'm sorry, I'm not following your argument, because my understanding of the argument was that he needed a waiver in 2006 before he could earn points in a new position in Asia. And he raised this, I guess I'm looking at JA 145, where the board acknowledges the contention of error resulting from, quote, his September 2006 requested relief from his fiscal 2006 obligations. And then JA 140 in 2019, acknowledging he was unable to participate from May 2006 to August 2007, quote, due to not receiving a transfer to a new reserve position. So I think he did raise that. And that, so, but what is your argument on the merits about why he was not prejudiced or that the board adequately dealt with this contention? Because from my reading of the board's decision, all it said was, they talk a lot about the inactive status issue. And then it says, and we see no unremedied errors. So what is the argument on the merits that was adequately addressed?
Sure. So I'll address both of those questions. First, I think it might make sense if I address your question regarding what the nature of the argument actually is. And it's the Secretary's position that this quote unquote waiver does not have to do with his ability to complete the 50 points in a given retirement or retention year. Instead, he indisputably received a bad R&R year in 2006. And as a result of that, he got what is effectively a black mark on his record. And sometimes, service members, reservists can be even discharged prematurely and not be permitted to continue with their active reserve duties when they don't complete a given
So you're just saying
year.
he's not entitled to waiver of that 2006 year?
Right. So it's the Secretary's position that there's no such thing as a way to just eliminate this bad R&R year that happened. And the way that we understand it is that it was just a way for him to actually just be hired, because he needed to find another job in order to continue in his reserve status. But because he had this black mark on his record because he had a bad R&R year, he needed some, acknowledgement from his command that, kind of excuses his failure to complete a good year. And that's what he was seeking. And I mean, to date, Mr. Coleman is pointing to no requirement that his unit, I guess, even grant this waiver issue. And so I guess that would be the Secretary's response to, I guess, the merits of the issue. I guess to get to the second point with respect to the forfeiture issue, I think certainly defendant's brief, defendant makes clear that it is understanding Mr. Coleman to solely be arguing about the transfer to inactive status. And while it is a little bit unclear because of the way that Mr. Coleman has framed the issues, what is clear is that he is only making an argument based on past decisions. And therefore, because this was never an issue that had been raised previously, it couldn't have possibly extended to this waiver argument, which was raised for the first time in the application for reconsideration, which is the fourth application to the board. And if you look specifically at the text, the Secretary makes clear that this is the understanding that he's making this argument with respect to the transfer to inactive status, and the court in its decision also makes clear that that was its understanding of the issue, because that was the only issue that was raised in that first application to the court. So I appreciate that he may have raised it in the background section of the facts, but this is a merits, it went to the merits of his argument, and there was no reference included. And certainly had the Secretary been on notice that he was raising this argument, I think the Secretary, of course, would have addressed it more clearly. And certainly I think the district court as well would have also addressed the issue had it been aware that this was the argument being made.
Thank you.
Right. We would ask that the court affirm the judgment of the district court. Thank you.
Mr. Thayer, why don't you take 2 minutes?
Brief for both, Your Honor. So my friend on the other side talked a lot about the waiver argument and how it wasn't presented in the district court. Your Honor, Judge Pan, I believe you said this, but it was argued before the district court. If you look on pages 5 and 6 of the plaintiff's motion for summary judgment, it's referenced very clearly. and it's referenced again by implication on pages 16 through 18, and the district court on page 13 of its memorandum opinion clearly makes reference to those pages. In the government's brief as well, the government, and this is on page 34 of the government's brief, the government states, while he, Major Coleman, is dissatisfied with the amount of time that it took for his unit to waive his service requirements, he does not identify any policy or regulation that compelled his unit to grant him the waiver. So the government has recognized that the way the waiver works is it waives your service requirements for a given year. That's stated right in their brief on page 34. There's also been a lot of discussion today from the government about how, you know, perhaps the arguments weren't properly presented because Major Coleman could have presented these arguments in his first application or his second application, but they weren't presented until his third application, or they weren't presented until the request for reconsideration. Here's the bottom line, Your Honors. Under 10 USC 1552, the Board for the Correction of Military Records in any military service department has broad discretion to correct any record in response to an application made by an applicant when there is a showing of error or injustice. It doesn't matter how many applications there previously have been. If the board decides to review an application, it has broad discretion to correct any error or injustice. The secretary was on notice that these arguments existed because they were in Major Coleman's applications. The board in 2016 said an error or injustice contributed to his discharge. He has been made as whole as this board is able or willing to make him under the circumstances. Now, I don't hang my hat exclusively on that one sentence, but it does show that the board recognized that an error or injustice contributed to Major Coleman's discharge. It declined to fully correct that injustice. That's arbitrary and capricious agency action.
All right.
This honorable court stands adjourned until Tuesday, February 25th at 9:30 a.m.